Hi, Brendan Lupitin from Myers, Evans, Lupitin, and Unitin, and I just want to talk briefly about what to expect when you contact our firm about a potential medical malpractice case. So basically, what's the process? So you were either referred to our firm or one of the lawyers here, or you saw a television ad, or you found us online and you contacted us. You believe that you may have a medical malpractice lawsuit and you want to find out if that's the case. So when you call us or you email us, the first thing that you can expect is that one of our nurses, we have two nurses that work on staff, is going to call you and schedule an interview. Sometimes they can do the interview that day, sometimes they do it a different day. Now, the interview takes about 30 to 45 minutes and gets basic information from you, your name, your address, key medical issues in the past, other important information, and then the nurses go through a detailed investigation from you to understand the facts about what happened in your case, why you believe there wasn't a lawsuit, and what you believe the injuries or the death was that was caused by the potential medical malpractice. Our nurses put all of this information into a case management system, and then they assign it to one of the lawyers or a couple of the different lawyers in the law firm for them to investigate the initial facts. If based on the initial facts of your case, it looks as though there may be a question of medical malpractice, then what we do is either a secretary or one of the nurses reaches out to you and will send you a medical authorization. Now, this medical authorization that you have to sign and return to us allows us to get your medical records. Now, the medical records are the bedrock of every medical malpractice case. They are the key piece of evidence in the case. While your recollection and your testimony is very, very important, the medical records make or break all medical malpractice cases. It's a rare exception when there's other evidence that allows a medical malpractice case to go forward if everything is not borne out in the medical records. Now, typically, once we get your authorization back, it takes a minimum of 30 days for us to get the medical records back from the hospital or your doctor. So that's just the 30-day process. Then it's going to take us a week or 2 weeks to review the medical records, create a medical summary and timeline, and then do the research necessary to determine, based on the facts of the case, whether there was medical malpractice and whether the malpractice, if it existed or occurred, caused serious injury or death. Now, if we review your case and we review your medical records and determine that there is not a case, then you will be contacted and we will explain to you the reason why, whether there's not accurate evidence of negligence or we have concerns about whether the damages were sufficient enough to warrant a medical malpractice case or whether there were causation issues. We will call and explain to you and give you an explanation to help you understand what happened, why it happened, and also why it doesn't rise to the level of a medical malpractice case. On the other hand, if we believe that your case and the facts and the medical records meets all of the different criteria, then we're going to invite you to come in, or we're going to send you a representation agreement so that we can begin to move towards litigation, which is the process of actually filing and undertaking a medical malpractice lawsuit, which I talk about in other videos. Now, there's an earlier step that sometimes happens, which is you call in, you talk to the nurses, and they can pretty much quickly determine that there's some problem with the facts of your case that make it so that we're not going to be able to handle it. Either the statute of limitations has run, or there's just obviously not negligence and maybe it was just a complication or a bad outcome, or the injuries that you believe may be related to the mistakes in question just clearly, our nurses can tell, are not related to the malpractice and thus wouldn't allow us to file a lawsuit. And that's the basic process of what's going to happen. If we determine that you have a medical malpractice case, we're going to invite you to come into the office, or depending on if you are that severely injured or simply cannot make it down to our office, we can come to you sometimes to meet you in person. But the key is to then make that personal introduction. Now, you may be asking yourself, well, hey, why can't I talk to a lawyer sooner, or why don't the lawyers contact me sooner? And the reason is because we want to make our decision as to whether there's a medical malpractice case based entirely on the evidence, because inevitably, with a lot of the people that we meet, something terrible's happened. We're human beings, you're human beings, we're going to connect, and that could potentially detrimentally affect our review and evaluation of the case. And that could conceivably cause us to pursue a case that really should not be pursued and would just really probably result in a bad outcome for all of us. And the last thing that our firm wants to do is to waste your time and to add additional insult to the tough situation that you're already in. We're not interested in doing that. We want to help, not hurt, and filing cases for the wrong reasons is only going to hurt things. So that's the reason why we don't meet with people typically before we've made the decision on the records themselves about whether the case looks like it's actual medical malpractice. When we do finally meet, if we've determined that we do think you have a case, you'll be able to ask us any questions you want. You can have as much time with us as you need. It's always a good idea to put questions together, ask other people about questions that you may have. You could always shoot us an email beforehand about anything you need to prepare or any questions you have ahead of time. But we are there to help you at that point. We want to help you with your case. We want to help you win. We want to help make up for what happened as best as can be done with our civil justice system. And then we basically hold your hand and take you through the process at that point. And with our firm, we are turnkey, meaning once we have decided that we have a case that we can represent you on, you can, if you want, just let us go and do our thing, and we update you as necessary, and we stay out of your hair if you want. Other people want to be more involved, and that's great too, and they want regular updates. We can do whatever you prefer. Our default is to periodically keep you updated, to reach out, see how you're doing, see if there's any new developments in the case from your perspective, and we hope that you do the same to us. And you know that you can always contact us by email, by phone, by text message. So we're very accessible once we have made the decision that we can help you. And we're always here to answer your questions. So that's the basic starting process of what is going to happen if I reach out and ask this firm, do I have a case? No matter what, you're going to get an interview, you're going to talk to somebody, and you're going to get an explanation one way or the other, whether you do or you do not have a case. So if you have any questions, give us a call, shoot us an email.